Hi, everyone, and welcome to the second in our series of webinars talking about Medicaid and how to protect your family and your assets from that program. We are very glad to be with you again on this seminar series. I'll talk more later about how you can get to look at part one if you missed it. But today we're going to go directly into our information about protecting your family and your home. Just a quick introduction of myself. My name is Tenney Lantz. I'm an attorney at Lantz Law, and here's some information about my background and where I went to school. And one of the favorite things that I have to do is to spend some time with my grandchildren when we get to do that again. And my associate here at Lantz Law is attorney Michael Coleman. Michael lives in Westport and has been with us for, I guess, about 6 years. He has taken the bar in both Massachusetts and in New York, which I think is a remarkable achievement. Michael works primarily in the estate administration and probate area, also does real estate law. And when he's free and he has time on weekends, he loves to walk with his cute little dog, Logan. We want to invite you to visit our website, which can be found at lantzlawinc.com. We have lots of information on that website for you about programs that we're running, how to contact us, what our specialties are, and so forth. So please visit our website. And we want to tell you about a couple of valued resources that we have available to us at Lantz Law. We are members of the American Academy of Estate Planning Attorneys. In fact, we are the only member of this prestigious organization anywhere in southeastern Mass, Cape Cod, or the islands. This entity provides us with our document production programs and gives us a lot of backup in the education area if something new should happen in estate planning and we need to know about it. Our second important resource is the NALA organization, that stands for the National Academy of Elder Law Attorneys, and we are members of the Massachusetts chapter. The American Academy and the National Academy do two slightly different things. The American Academy deals more with the estate planning realm, and the National Academy tends to deal with Medicaid and elder law and special needs law. So in both of those situations, we have some great backup to the already important information that we have to give you. Now, when it comes to Medicaid law, you have a number of planning options. We're going to go through each of these and give you a little more information about them. First is the irrevocable trust, irrevocable income only trust. Then there's a concept called Caregiver Child. There's also a type of annuity that you can use called a single premium immediate annuity, or SPIA. There are special needs exemptions in the law. We want to talk to you about all the transfers that you can make to your spouse, and then we'll talk about other transfers as well. So what is this thing called an irrevocable trust? People come in and want to talk to us about using that vehicle to protect their home, but they're not quite sure what it is. Well, there are lots of different kinds of trusts, and this is a specially drafted one. It is irrevocable. So once you sign this trust, you can't make changes to it. You also have to name someone else to be the trustee of this trust. Unlike the usual revocable trust that we use, in which you are the trustee, in this case, someone else, usually a trusted child or a trusted friend, would be your trustee. Once you put an asset into this trust, you no longer have access to the principal. but you would receive any income that is earned inside of this trust. And this is used primarily to protect your home. Remember, though, that you have a 5-year waiting period with this, just like almost all of the other means that we're going to talk about to protect your assets. So how does it work? Well, we like to think of a trust sort of like a treasure chest. And what you do is you put an asset into that trust, into that treasure chest. In this case, our traditional couple named Bill and Mary Jones have a very responsible daughter named Susan. And so they named Susan as their trustee. Bill and Mary live in the house inside this trust just as usual. And they get to pay all the bills, the real estate taxes, the utilities, the insurance, and so forth. And if something should happen to Bill and Mary, the trust has the house transferring to their beneficiaries, their son John and their daughter Susan, directly without any probate action involved at all. So in this sense, the trust for irrevocable purposes works very much like any trust. It avoids probate. Now people say, okay, but I'm not the trustee. Can I sell my house? And what if I want to move or downsize? Well, yes, that can be done. Both of those things can be done, but it's not you who would do the selling, and it's not you who would receive the principal. The trustee can sell your house, and the trustee can either buy another smaller house and put that inside of your trust for you to live in, or they can obtain the principal and inside the trust invest that principal in a way that would be helpful for you. So you would receive any earnings that that principal received. So there are lots of possibilities with this irrevocable trust. It's not quite as flexible as the revocable one, but nevertheless, it's really a useful kind of vehicle to protect your house from the nursing home. Another means that people can use is something called a caregiver child. Now, this is a bit tricky. This means that your child, and it can't be a grandchild, it can't be a nephew or a niece, comes to live in your home for 2 years. And during that 2-year period, that caregiver child helps you to stay out of a nursing home. Maybe they do all your grocery shopping, they do the cooking, they may do the cleaning, laundry, all those kinds of things that would allow you to stay in your house. And at the end of that 2-year period, if they have given you all of that care and have kept you out of a nursing home, then you can gift that house to that child with no Medicaid penalty. So this is an important exemption to keep in mind. The other requirement of this exemption, though, is that you must get a doctor's letter that would be provided to the Medicaid office to prove that by having that care for 2 years that your child provided, that they kept you out of a nursing home and therefore saved the state the money of the nursing home for those 2 years. But you want to review this with somebody who's knowledgeable about the program and not just do this kind of willy-nilly. Now, if you have children who have special needs, or maybe a spouse who has special needs, somebody that needs your help in the long run, you can provide your assets, your resources to a special needs trust, and then there is no penalty for gifting into that special needs trust. Again, it's a very tricky proposition. You want to do this only with somebody who knows what they're doing and can give you the kind of advice that you need. Here is another little tricky means of protecting your assets. A SPIA stands for a single premium immediate annuity. It's a special kind of annuity. It's purchased from an insurance company. And what happens with this is you give to the insurance company the money that you need above the asset limit that we talked about last week in order to make yourself or your spouse eligible for Medicaid. That money gets invested in an annuity in your spouse's name if you're the person in the nursing home, or in your name if it's your spouse who's in the nursing home. The annuity would pay out monthly, like a monthly income source to you over the period of your lifetime. And this is a very useful way of saving your assets, making sure that they all come back to you, and yet avoid the penalty that might be otherwise imposed by Medicaid. Again, please talk with someone who's knowledgeable about this. Don't try to do it on your own. Now, spouses can transfer from one to the other and back as much as you want. There is no asset limit to the transfers that you make to spouses. So if you are the ill spouse and need to go into a nursing home, you can transfer your assets to the well spouse, and there's no penalty related to that. Remember, there is the asset limit that we talked about last week. So don't do this without talking to a knowledgeable advisor. Whatever you do for transfers, you must make sure that you do those transfers before the 5-year look-back period begins, because you will get a penalty if it's within that 5-year period. Other things you might do would be to purchase an interest in a child's home. You could even buy a business, and that might be an eligible investment for you. But do it with somebody who can tell you the right way to do it, and be very wary of that 5-year look-back period. What can you do? Well, if you think a nursing home is in your future, do something now to protect your assets. Plan ahead, plan ahead, plan ahead, because that 5-year look-back period is lurking out there. And remember, be nice to your children, because they will probably choose your nursing home. And be nice to your lawyer, because they will help you protect your assets. If you're worried about your assets and you're worried about a nursing home getting their hands on it, we can help you to protect you, yourself, and your family. But you need to take action now. And if you missed our first webinar, you can visit our website at lantzlawinc.com and find it under the blog category. I hope you know what that means, because I don't. But anyway, we'd also like to let you know that our office has reopened, but by appointment only. If you'd like to schedule an appointment, please give us a call at 508-998-8800. Thank you so much for listening, and we hope to see you again at our webinar next week.